Hello, everyone. My name is Dr. Jacqueline Renishek, and I'm with DTP-Leadership Group. This is Hot Topic Bold Talk, and I'm privileged to have Richard with me today because he's my legal expert that's going to help us understand Donald J. Trump versus Rebecca Kelly Slaughter. It's quite a case that I think is important. Now, I was talking with Richard, and I want to tell you I'm not the lawyers, but I want to tell you what my thoughts were about this case. My general comment is that the Supreme Court has taken Humphreys, which was a case that established standards for years, and done the same thing they did with the Voting Rights Act of 1965, Section 2, was to try to destroy the arguments in both of those situations to build a case to eliminate the value of Humphreys. So we're going to talk about Humphreys today, but we're going to talk about many other things as well. Now, unfortunately, what I think that you need to understand is the Supreme Court has given the president the right to fire anyone that appears to be in the executive branch of government with no guidelines for him about how he can fire them or what they're going to be fired for, whether it's their behavior or actions. So there's no guidelines for him. And I think that is certainly dangerous. And so I think this is a case that I'm going to ask the listeners to really listen to what Richard is saying today, because you will want to understand this and be very clear about what's happening with this particular case. So I'm going to ask you today, Richard, what's Slaughter looking for? And then what is her argument first before we get into the Supreme Court argument?
Sure. And thank you for having me again, as always. Um, Rebecca Slaughter, the plaintiff in the lawsuit, was appointed to the Federal Trade Commission in 2018 by Donald Trump. During the Biden administration, she was subsequently reappointed to another term. The Federal Trade Commission is made up of 5 commissioners that make decisions on a broad range of topics concerning commerce in particular. When Trump came back into office in 2025, he attempted to terminate Rebecca Slaughter as a commissioner on the Federal Trade Commission. Slaughter in turn filed suit and said the president did not have the right to terminate her at will. Trump did not give a reason for her termination. She relied upon the statute allowing for the appointment of commissioners to the Federal Trade Commission, that the requirement be for what I will generally refer to as cause, and that there was no cause for her removal. Now, in the district court, Slaughter was able to obtain a summary judgment in her favor. The reason for that is there is a 1935 U.S. Supreme Court case called Humphrey's Executor. And the 1935 case concerned William Humphrey, a former commissioner on the Federal Trade Commission, who FDR tried to remove at will. And in that case, the Supreme Court said the Federal Trade Commission performs many duties that are outside of the executive branch. It has certain duties to establish guidelines and regulations that can be enforced, and in that way it performs a lot of legislative functions. So in Humphrey's Executor, the U.S. Supreme Court said, because this commission is not purely executive, we don't believe that the Constitution's grant of authority to the executive to appoint commissioners and by extension to fire them applies to this commission. This is not something the president can do at will. So what ended up happening is Humphrey passed away about 4 to 5 months after filing his lawsuit. So the reason it's called Humphrey's Executor is his estate was awarded back pay for the time frame that he should have been on the commission before he passed, but had been removed by Roosevelt. Coming back to Miss Slaughter, she pointed out that she had a case directly on point. The trial court agreed with her and granted summary judgment in her favor. The executive branch then took the case up, sought a stay, and the case ultimately ended up in the United States Supreme Court, where the executive branch, President Trump, was arguing that Humphrey's executor was no longer good law and needed to be overruled. So that was what Miss Slaughter was looking for. She had a case directly on point and said, well, the Humphrey's executor case says he can't do this. And the district court pointed out, well, yeah, there's Supreme Court precedent directly on point. I've got to follow it. And it did so, which then brings this case before the U.S. Supreme Court in this past term.
Okay, so one of the things that I hadn't thought about, Richard, but I think would be helpful. What are some of these commissions that have commissioners on it that are not under the purview of the executive branch? Could you give me an example or two?
Well, let me qualify my answer.
Okay.
After the decision we're discussing today, Slaughter, there would arguably be very few. Um, the one example I can think of offhand would be the Federal Reserve Board because of the Lisa Cook case that was handed down the same day, where the Supreme Court said, well, the Federal Reserve Board is not something that falls under the Article 2 appointment, where the president can remove governors on the Federal Reserve Board at will. However, prior to this decision in Slaughter, there were numerous, and there still are numerous federal agencies that do not just perform truly executive functions. In Gorsuch's concurrence, he goes through some of the statutes creating these agencies, and essentially, in addition to the Federal Trade Commission, there is the Federal Communications Commission, which has certain enforcement power and the power to hand down regulations. Most listeners should be aware of that because of threats that have been made by the chair of the Federal Communications Commission in relation to some jokes made by Jimmy Kimmel about the current president of the United States. Another example is the Securities and Exchange Commission, which has certain rulemaking abilities and administrative proceedings to enforce those abilities that are both legislative and judicial in nature. The same is true with the Federal Elections Commission, which has the ability to impose fines to people that violate the election rules regarding the reporting of contributions, things of that nature. So that is 4 or 5 that I think a lot of our listeners will be familiar with. There are others. The Consumer Financial Protection Bureau, which was established, I believe, during President Obama's term, would arguably be one such agency. But there are a substantial number of them. The environmental, regulatory different agencies regarding, the environmental controls and enforcement. So there are a lot of these types of commissions and agencies that exist. And under Humphrey's executor, those types of agencies, if the statute that creates them provided that the commissioners, governors, whatever the positions are called, could only be removed for cause, that limited the president's ability to remove those individuals.
Okay. And one of the things I think about all of your examples is we don't want one person to make a decision about, the Federal Trade Commission or many of the other things, because we are trying to protect the rights of American people to do business in ways that are acceptable and ways that we can protect our environment or a number of other things. So I appreciate you giving us at least a few of the examples. You mentioned, though, with this case, there could be some real possible changes in what is happening with these various agencies where they have enforcement, but they may not, they may not, they may not come under the executive branch. So if, unfortunately, Richard, I don't think in this case they have distinguished between which agencies and commissioners are not under the executive branch. So I think we can talk about all these issues, and I know you're well prepared today to talk about all the issues and talk about the threats with this particular decision. So I'm going to stop now, but I just wanted to mention those to try to get people to look at it. I think Humphreys is extremely important. So could you please go into a lot more detail, because for 90 years it has been it has made the rules for a lot of these agencies and commissioners.
Yes, and um, you know, from a background standpoint, there were many cases when FDR was working to push through his, you know, New Deal legislation where the Supreme Court was stepping forward and invalidating many of those statutes. Um, as one of the opinions points out, the Humphreys Executor case might have been the decision by the Supreme Court that aggravated FDR the most and led him to want to try and hack the Supreme Court all the way back in 1935, 1936. Um, Ultimately, what we get down to is Humphrey's Executor, where you had these agencies, ultimately put certain limits on the ability of the president to remove the people that run those agencies. The idea behind Humphrey's Executor, from a conceptual standpoint, is where we've got these administrative entities that have been created in the federal government that are supposed to be nonpartisan. We want to protect them from purely partisan appointments and protect them from having complete and total turnover every time we have a new president elected and taking office. And some legal scholars that I have read have opined that the Slaughter case will be the most significant case decided by this court during President Trump's second term. Because ultimately, what we're talking about, and we can get into the history and the analysis and what led the court to this 6-3 decision, ultimately what we're talking about is, with a few exceptions, like I said, the Lisa Cook case handed down the same day made it clear the president doesn't have the right to terminate members of the Federal Reserve Board at will. So that's one federal agency that we know is safe from termination at will by the president. Another type of federal appointment, while not a federal agency, that the majority opinion indicated would arguably be protected under the standard it set up in Slaughter would be certain court appointments, like judges in tax courts, where the the tasks that they're performing are purely judicial in nature. So if those appointments are designed to be for a set term where they can only be removed for cause, those types of appointments very well may be free from being terminated for cause. But ultimately, what you now have is you have a circumstance where commissioners on the EPA, commissioners on the Commodities and Futures Trading Commission, commissioners on the SEC, the FCC, the FTC, the Elections Commission. There are more federal agencies that I can count where ultimately what the Supreme Court allowed by the Slaughter decision is every time someone new gets elected, in addition to um, all of the other changes that occur whenever a new president takes office, such as, the cabinet members being appointed by that president. Now we're talking about a president being able to just completely wipe the slate clean. With regards to the SEC, the president can whack all of the commissioners and appoint the people that he or she chooses. And the same is true with the FTC, the FCC, all of these types of administrative agencies that form quasi-executive functions are now free for the employment in these agencies to be at will, which means regardless of party affiliation, every 4 years there's going to be a massive level of upheaval. There are arguably going to be massive vacancies that affect the ability of these agencies to adequately perform their functions for a period of time until new people are appointed to fill those positions. The agencies are going to become more political. With many of these agencies, the idea is we don't just appoint people that are former members of Congress or former governors. The idea is with the Environmental Protection Agency, we're
Right.
appointing people that are scientists that understand what we're asking them to do. And ultimately, what we've done is we've created a new playing board, a new monopoly board for the president, where all of these agencies are now subject to political appointments and they're going to turn over every 4 years. And the other problem I think that we could foresee happening is even where you've got presidents that want to appoint qualified people that can appropriately do the job of some of these agencies. To be blunt, if a commissioner's position was offered to me, why in the hell do I want to leave my job in the private sector and set aside 30 years of practice and the client base I've built up to take an appointment on a commission for 8 or 12 years when I know the reality is I'll only be on that commission for 4 years tops? So what you're going to have, I think, is you will have many qualified people that will no longer want to serve because they understand, best case scenario, I'm in this job for 42 months.
Yeah, and I think that's the thing that really worries me about this case. So what I think we have to do is we know what Humphreys was about, and we know what was established. It had some very good guidelines that were very clear, and it established a lot of these agencies being enforcers and somewhat separate from the president. So I'd like for us to, one of the things that the Supreme Court did, that Slaughter herself did, and that the dissenting judges did, was they went and looked at the history, the federal papers, the history of what the founding fathers were doing. And I think it's important at this point to describe what we see as what our founding fathers said and what the Federalist Papers said and some other things about the history, so we can show how the Supreme Court changed some views of these experts in order to have their decision they made. So
Yes. Uh, um, the majority opinion in particular begins with, and for a lot of our listeners know, but okay, the U.S. starts as an independent nation after the war. And originally, the U.S. was governed under what were referred to as the Articles of Confederation. And in large part, the government is set up then was designed so that there wasn't too much power in one person's hands. It was a reaction to not wanting to have another king. In, I think it was 1787, the founding fathers and others involved in the government realized that the system that they had set up wasn't really working very effectively. Having all of these decisions made ultimately by committee had many problems. And the majority points this out and points it out as the basis behind the Constitutional Convention, and in particular, the creation of the executive branch and exactly what kind of power was desired in the executive branch. They go through discussions over different languages, and in particular, the power of appointment and by extension removal is in Article 2, Section 2 of the Constitution. And to read the particular phrase at issue, he, referring to the executive, shall have power, by and with the advice and consent of the Senate, to appoint ambassadors, other public members, and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. So, if the means for appointing those people was not set up in the Constitution, it was left to the president to do with the advice and consent of the Senate. Now, the debate that goes on, and essentially there were two views behind that language and its intention at the Constitutional Convention. The court talks about three views, but I think there are two views that are really important and bear discussion, because those are the views taken by the majority and the dissent. The view the majority adopted was the view expressed by then Congressman, eventually President Madison, which was that, look, there needs to be more power in the executive, and even if the appointment is with the advice and consent of the Senate, if the president finds that the people that he has appointed to act as his functionaries, to act as his agents, and do what he wants done, are not doing what the president wants done, he should be free to remove those people without having to seek the leave of the Senate for their removal. The counter view, espoused by Alexander Hamilton, yes, the same Hamilton about whom the musical is written, was that if the appointment may only be done with the advice and consent of the Senate, then by extension, the removal must only be done by the advice and with the advice and consent of the Senate. This was a dispute that ultimately happened 100 years earlier in the Myers case, which Humphrey's executor chose to deviate from. That case involved Myers v. United States, which involved a postmaster in Portland, Oregon. And in that case, then Justice Taft, formerly President William Howard Taft, went through the history, and he argued that ultimately, despite the views Hamilton expressed during the Constitutional Convention, Hamilton came to agree with Madison and adopt the other view. But one way or the other, the view Hamilton took to that language where there was not explicitly a right to removal was that removal also had to be with the advice and consent of the Senate. The view Madison took was that once they were appointed, the president could fire them at will. And ultimately, the majority goes through that view. The majority talks about the ultimate adoption of that view, and the prevalence of that view is becoming the more preferred and more commonly accepted understanding of the president's appointment powers over time. Then the majority acknowledges Humphrey's executor and the rationale on which it was based, that, okay, if we're talking about offices that are not purely executive, then Congress can, in establishing those offices, establish limits to the removal of people from those offices. What the Supreme Court does is it takes a different view, where Humphrey's executor looked at some functions being performed by the Federal Trade Commission that were legislative or quasi-judicial. Essentially, the Supreme Court in Slaughter looks at this from the other side of the window. They say, well, if there are functions that this commission performs that are within the executive authority, then the executive can remove these people. And ultimately, the decision the majority makes is President Trump can remove Lisa Slaughter at will, even though the statute permits removal only for a cause. The court ultimately decides that the law's limitation on the power of removal is unconstitutional, that it runs afoul of Article 2, Section 2 of the U.S. Constitution. Now, this is another one where, like the Barbara case we discussed last month, you've got two sides arguably taking a strict construction of the Constitution, and the variance of their interpretations is in the different ways in which they define either the language that is in the Constitution. Last month it was subject to the jurisdiction thereof, or the language they choose to use to fill in gaps in the Constitution. Again, this is the U.S. Constitution. Pretty thin, pretty small. It's very much unlike state constitutions that can be, 1,000 pages thick. There's a lot that is left to interpretation, and that's ultimately what it comes down to. It comes down to a matter of interpretation. The view taken by the minority, Justice Sotomayor writes that opinion, is that, look, we agree with Hamilton's point of view. And here's some historical bases for Hamilton's point of view being the right way to view this situation. And if limitations can be placed on the power of removal under Article 2, Section 2, if it is not solely at the will of the president, then Congress can define circumstances where the president can act and remove people. Congress can limit it or expand upon the president's right of removal. So it all has to do with whether or not appointment with the advice and consent of the Senate allows removal without the advice and consent of the Senate, because the Constitution is silent on the issue of removal. The six-person majority, or the six-judge majority, says, yes, advice and consent is not needed for removal, which is what the court decided in Myers 100 years earlier. The two-person minority, I don't think Justice Jackson participated in this decision, said, no, there can be appropriate limitations on the right of removal. No, here's the one thing I would point out, is that there's no, how would I put it?
Let me say one thing.
Sure.
Jackson's name is on the dissent along with Sotomayor and Kagan. So she did include herself in that.
Okay, I was not aware of that. I thought it
Yeah.
was a 6-2 decision, not a
Well,
6-3 one.
I'm sitting here looking, and it's Sotomayor, with whom Justice Kagan and Justice Jackson
I see.
join in the
Sotomayor filed
dissent.
a dissenting opinion in which Kagan and Jackson joined. Okay,
Okay,
my
got it.
bad.
No, that's
That
okay.
one's on me.
Okay.
Um, but where I was going to go is honestly with the amount of governmental duties that have been placed in these administrative bodies. There is no um, clean, perfect way to go about it because arguably, if we were to impose on certain agencies the requirement that the president obtain the advice and consent of the Senate to remove individuals from these offices, then I know a lot of our listeners are going to say, well, hell, the Senate doesn't do anything to begin with these days. But
Right.
arguably, the Senate could be left occupying a large amount of its time simply voting to remove people from different commissions and boards and the like. So, to read it, the problem with it, given how large the government has become, is there can be pitfalls to each side of this argument in circumstances where the statutes creating these commissions have not set up appropriate guardrails for the removal of commissioners or governors or whatever positions exist therein. So I just want to make that point. And like I said, ultimately the way I view it is um, I am not persuaded that based upon the language in the Constitution, one side or the other truly has the better argument because the Constitution clearly is silent as to the issue of removal. Um, but the two things that really lead me to believe that the Supreme Court got this one wrong are one, the consequences of what they have done,
Right.
um, which Gorsuch touches upon in his concurrence, and and and
Wait, before we
and
go to,
two,
wait a
the
minute,
issue of stare
Richard.
decisis.
Richard,
Yeah,
wait a minute.
yeah.
Before we go into Gorsuch, can you be very clear? Because I found reading this case that I found the ones that made the decision for the Supreme Court, they seem to be trying to build a case uh, that I thought was very simplistic with a very complex situation. So can you be more clear on what the Supreme Court really did? And then we'll go into the consequences of it, or we can go into looking at what Sotomayor and Kagan and Jackson said, because I think some of their points are well taken, that counter what the majority did.
Uh,
You know,
Well, and I agree with you. I mean, ultimately, what the Supreme Court did was they pointed out that in Myers v. United States, the Supreme Court 100 years earlier had decided there is an at-will right to removal of executive appointments. And then 8 or 9 years later, they said in Humphrey's Executor, well, there are certain executive appointments that we're going to carve out of the broad grant of Myers. And I think Humphrey's Executor may have been a unanimous opinion. Um, I cannot recall. I know there was a dissent in Myers, but I don't think there was a dissent in Humphrey's Executor. You know, the and ultimately what the majority does is they say, look, Myers was the general rule. Humphrey's Executor is the exception to that rule. And applying the law today, the Federal Trade Commission doesn't fit within the framework of the appropriate exceptions to the president's ability to terminate agency appointments at will. That is ultimately the simplistic ruling or decision. No, no, the second point I was going to come to, and the problem I have is um, the concept is called stare decisis. And essentially, when we've got a settled opinion from the court, it should be left alone. And the court goes through this analysis why, no, we don't have to leave this alone. We can overrule Humphrey's executor. But in overruling Humphrey's executor, yeah, I talked about the ability to just terminate so many of these people at will, but it's something that I really think Gorsuch touches upon the most in his concurrence, which is look, beginning in 1935, when the Humphreys executor case came down, and again, it was a unanimous decision, what Congress then realized is okay, we can delegate certain responsibilities to the bureaucracy, to agencies that we establish. And where Congress did that, it did that with the understanding that we can set limitations on the removal of people appointed to these positions. That is one of the issues or elements of stare decisis. I mean, it's essentially if we pull this card out, is the whole damn house going to come down?
Mhm.
And what the three-person dissent says, and what Gorsuch honestly agrees with, is that yeah, we have just set aside 90 years of laws that were passed, or statutes that were passed and became law based upon the belief by Congress that they had the ability to do these things, that they had the ability to create nonpartisan agencies by setting terms of 6 or 8 or 12 years and setting limitations where someone could only be removed for incompetence or conviction of a major crime, things that make it clear that they are now unfit to hold the position.
Right.
And Gorsuch points out that yeah, we have just upset the apple cart. There are a lot of agencies out there that now are basically being turned into they're no longer safe havens, they're no longer nonpartisan. We're turning them into partisan vehicles.
Thank you. And I think that's very clear. And that's what I think really scares me about this case, and particularly at this time in history with the current president we have. So what I want to do is one of my questions to you at the beginning, and I showed it to you, is that how does this decision affect the founding fathers' desire to protect us from a monarchy? And how does it truly affect the three branches of our government? Now, I happen to know the only one that's functioning right now is the judicial branch. The congressional branch is basically controlled by Trump, so they do what he says or they lose their position. But my thing about this is this decision, I think, affects and gives more power to the executive branch, or I may be wrong, but I I don't think that the founding fathers established three branches and said, okay, now we're going to make you Supreme Court have the right to make a decision that's going to make the executive branch much more powerful than the rest of them. Because I think of all these agencies and all these commissions you're talking about, and now this whole shift to partisanship, when I think the Congress thought it was literally building agencies and commissions that were nonpartisan.
Yeah. Okay, two things, three things, four things, a lot of things. To start with, I would take issue with one thing you said. I think
Okay,
there are two branches of the government that are currently functioning. You may not like the way the executive branch is currently functioning, but it arguably is functioning. Maybe not in the appropriate fashion, but it's still functioning.
okay,
Okay, now moving beyond me taking issue with that statement, going back to the past 90 years and what Congress has done, Congress delegated substantial amounts of its legislative power to these governmental agencies. By now making those agencies subject to the control of the president through the at will termination of the members serving on those agencies, the executive branch has just been made far more powerful, in my opinion, than either of the other two branches of government. The judiciary can ultimately say, you can do this, you can't do this, but at the end of the day, there has to be a reliance on the executive branch following the guidelines or guardrails set down for it by the judicial branch. Um, so, going back to the concept of our founding fathers, which is what you were touching upon, this decision probably takes us closer to um, not a monarchy, because the position is no longer would not be held by birthright, but certainly some form of regime where you have an oligarch or a substantial amount of power being placed in a single individual, so that the function really is not that much different from the monarchy the US tried to break from. And if I recall correctly, Justice Sotomayor touches upon how the majority's view or opinion really runs afoul of what was intended when this country declared its independence. That even in even in 18th century England, there are certain limitations that had been placed upon the monarchy that are greater limitations than are now being placed on the executive branch as a result of this decision. So yeah, it concerns me when you have someone like King George the Third, who wasn't in the proper mental state due to suffering from porphyria, or President Trump, whatever his faults may be, that when you have someone who does not make sound decisions,
yeah,
that damage, substantial damage can be done to this country. I mean, what is the quote that was attributed to Benjamin Franklin after the constitutional conviction? It was something like, "What have you given us?" And he says, "A republic if you can keep it." And yeah, what have you wrought? His answer, "A republic if you can keep it." And you know, I wasn't alive 150 years ago. I would argue that the Civil War was a greater level of upheaval to the idea of the United States than this is. But but again, I think the reason listeners should be concerned is um, the person that holds the White House and with whom we may disagree is not always necessarily going to be a member of the opposing political party. Going back to 90 years ago, Franklin Delano Roosevelt was trying to exercise a substantial amount of power as
right,
a member of the executive branch or as the president. And at that time, it was the Supreme Court through cases like Humphrey's Executor that set up certain parameters to rein in Roosevelt's efforts to ultimately create what's now referred to as the unitary executive theory, where pretty much all the power is placed in the White House through executive orders, through at-will appointments, through at-will firings. I mean, it a lot of the structure of our government is set up based upon kind of unwritten rules, if you will. No, it's not baseball, but there was nothing that limited George Washington to 2 terms. Washington ultimately only served 2 terms for fear that he might accumulate too much power and might be seen more like a monarch. It was a decision he made supposedly for the good of the country. And I would note that after Washington made that decision, for roughly 140 years, everyone else followed his lead until FDR, again, a Democrat in the White House, decided, nah, I'm going to keep running. And ultimately, after FDR was no longer in office, a constitutional amendment was passed to limit the president to 2 terms. Prior to the constitutional amendment, it had always simply been kind of a, pardon the sexism of the remark, something that was done by a gentleman's agreement. The same is true of presidents placing their assets in a blind trust so that they could make decisions for the good of the country as a whole, as opposed to decisions that would be more beneficial to their pocketbook. There is so much of our current system of government that is largely based upon these civilized guidelines or civilized conduct in society that the current executive really hasn't followed.
Right.
I mean,
Refuses to
the
follow.
concept of attempting to fire Miss Slaughter, even though you had the Humphreys Executor case, arguably it was done wholly to test and attempt to overrule a decision that had been previously criticized by members of the current court. Essentially, like the Dobbs case with abortion, this was a softball to see if the court is currently configured would overrule a case that the existing administration finds to be problematic. And lo and behold, the court did so.
Right. And I'm so glad you're going into the detail of this. And I'm so glad you've explained it because I think you've done a fabulous job in doing that. I think I would like to do something. I would like to read some of the dissent by Sotomayor and Kagan and Jackson, if you don't mind, because I would like to have you make a comment about some of them, and some of them I just think need to be read. You highlighted them for me, but they make sense to me. And I think they will also make sense to the listeners. So there's one in particular on the very first page. In these and many other areas, the wisdom of centuries has taught that some decisions should depend not only on who's in office, much less on who is disfavored or owed a favor by those in office, but also on judgment, expertise, and the public good. I don't think this case has supported the public good. And I think they're giving us a message here. So what do you think the message is in this paragraph?
Well, and this is, I've discussed this with you previously, that a case we haven't talked about, the Loper case, unruled a concept called Chevron deference. And I'd like to focus on that because that was the reason I highlighted and put the comment by this language. I touched upon so many of these commissions being nonpartisan, but another element of it that, and again, Gorsuch touches upon this in his concurrence as well, is that many of these bodies are established and the people appointed to them are people that have scientific or technical expertise, people who know what they're talking about when it comes to, um, uh, you know, the regulation and approval of drugs, people who, know what they're talking about in reserve to the Federal Reserve Board with about monetary policy, people that understand that cutting interest rates just because that's what the president wants to do would ultimately be problematic to the economy because it could cause the type of hyperinflation that other economies like Argentina and Mexico and Venezuela have experienced. Too much money ultimately leads to everything costing more. Says the lawyer who has only a pedestrian understanding of these economic concepts. But so many of the appointments are made focusing on the technical background and credentials of the people serving on a particular governmental agency. And for me, ultimately, what she's pointing out is that laws that were established to protect the country ultimately have been turned on their ear by the decision. The wisdom of the centuries has taught us that some decisions should depend not only on who is in office, but also on judgment, expertise, and the public good. And ultimately, here, the point being made is that with this decision, ultimately, these decisions are now solely dependent upon who is in office, with rare exceptions like the Federal Reserve Board.
Yeah, and I think there is one other thing that she talks about later on. It's on page 48, Richard, in her
Okay.
dissent. And I think I want to read it because I think that's when I felt disturbed and really clear about what was going on. She says the majority decision continuing that trend today is egregiously wrong. In this case, the court takes one of the oldest debates in American history and decides that 6 justices in the majority alone ought to be the ones to settle it for all time. That decision does not just overrule precedent, it all but ignores that precedent exists. It does not just hamstring the political branch's ability to respond to new challenges, it rewinds the clock nearly 150 years, holding that a common agency structure is and always has been forbidden. It is true that today's decision does not eliminate the FTC or many other agencies whose structures are implicated by overruling Humphreys. It is undeniable, however, that those agencies will be transformed in ways that those who created them never would have expected and actively sought to avoid fundamentally the balance of power in this country in the process. And then she goes on and says, will those transformations yield the benefits sounding in responsiveness and accountability that the majority touts, or will they risk placing in the hands of a bold and designing man of high ambition an instrument of the worst oppression, which will sacrifice every principle of independence to the will of the president? And the reason I read that is because I think these 3 justices were speaking to us and trying to tell us what's going on. So I'll be very interested in what you have to say with those comments.
Yeah, it's starting off with, 6 justices in the majority alone ought to be the ones to settle it for all time. Um, there was a question you asked me before we went on air, which is, um, will this decision always be there? Or will this always be the law going forward? I think was the more artful way in which you asked it. And my answer was no. The same way that this court overruled Humphrey's executor, if you arguably have a change of just two justices that disagree with the majority's point of view, we could have a circumstance where multiple decisions made in the past 5 years, the Loper case that overruled Chevron deference, um, the Dobbs case that overruled Roe v. Wade, um, the election um, uh, cases that we've talked about, Calais and Louisiana, and this case, Slaughter, could be overruled by another, a different configuration of the court that basically says in each of those cases, look, we had case law that was around for 50, 80, 90, 100 years. And through a simple majority of this court in 5 years, um, many of the rules governing our society were set aside by just a handful of people. And that's really kind of to me the underlying message of the opening sentence you read. Now, ultimately, at the end, the one sentence you did not read is neither I nor the majority knows with certainty. Arguably, she's probably talking about knows with certainty what will happen as a result of this decision. And why do I say that? Well, she cites a case from from the story versions of the U.S. Supreme Court opinion. So we're talking about you know close to 200 years ago. The statement was made by the court. Will they risk placing in the hands of a bold and designing man of high ambition an instrument of the worst oppression? Well, in the wrong hands, a lot of damage can be done. But arguably in the right hands, someone with the character and intelligence of an Abraham Lincoln or a George Washington, choosing two people that were so long, that held the position so long ago that none of us lived, and that hopefully everyone will acknowledge are beyond partisan politics. Well, in the hands of someone like that, arguably putting so much power in the executive branch could prove beneficial to the country. It would allow things to be done much faster. But, there are certain concepts ingrained within our Constitution. The idea of guilt beyond a reasonable doubt. The whole idea there is it's better that 100 guilty men go free than one innocent man goes to prison. Let me try that again. It is much better for society if 100 guilty men go free rather than one innocent man goes to prison. So the whole concept and the idea behind many of the elements of our founding documents of the Constitution was an idea of, well, let's set up these guardrails to protect against the really bad thing, even if it could prevent a really good thing from happening. And in that regard, even though there's no language in Article 2, Section 2 of the Constitution I can point to support her opinion, I think that there are certain concepts that are kind of accepted as being part of the fabric of the Constitution that support this statement and the ideas behind it. But that's just me.
I know, but Richard, I know you well, I think, and to me, your ethical, honest, straightforward ability to admit the two different points of view, how both had possibilities. When we're showing the points of view, and yet we're showing the consequences in this current day situation, then I think that's the best thing we can do for our listeners. And that's the reason I chose you as the lawyer that I wanted to work with, because I respect who you are. And I trust that you make the greatest effort possible for us to fully understand or somewhat understand what is happening with each case. So I just want to say that I've certainly learned a lot in this situation. I'm I said to you, this is a case that I really understood finally, along with the others, and had more ideas about what it was. It made a lot of sense to me. I certainly am more in the dissent group than I am in the majority. But I want to thank you. I want to give you a chance if there's anything else you want to say before we end this podcast, please do so at this point.
Yeah, and I touched upon this and may have already said it, but to me it's worth saying again. And your listeners can feel free to disagree with me. But ultimately, while I cannot point to a particular word in the section of the Constitution that we're dealing with that I would say clearly supports my viewpoint, to me, you know, I, I am concerned more about this decision than any other because, and again, we've touched upon this already. Ultimately, what we have is almost a century of the legislative branch saying, okay, we're going to move these powers into administrative agencies and let them make these decisions. The Food and Drug Administration will decide what drugs meet the appropriate guidelines to be safe for use in the United States. And now, arguably, as many viewers are seeing with the current configuration of Health and Human Services, and the ability to make these political appointments, not necessarily based on expertise, but on partisan politics, there are concerns about exactly where we're going. And that is, it's simply another specific example I'm giving, but I agree with the dissent for practical reasons. I can't say that, yes, I definitely think they've read the text of the Constitution right, but let's face it, there have been many important decisions in the history of this country where you cannot find specific language in the Constitution to support the decision. The decision was made largely on practical grounds because it was just the right thing to do. The one that immediately comes to mind is Brown v. Board of Education. And I
Right.
fear that unfortunately, with this decision, for practical reasons, the court has gone in the opposite direction. And that's
Thank
where I'll
you,
end it.
Richard. And I appreciate you ending it that way. And always, I'm very grateful. I want to ask my listeners to possibly listen to this one again, because I think you're going to learn a tremendous amount. And I think one of the things, Richard, that I know is any individual voter has a voice. And so when the election time comes, we can help make some of those decisions. And then it may take some time for us to change things, but we certainly have the power with our vote to help make the decisions in our country. So thank you so much. And I'm going to end this podcast at this point.